So check this out. Today in the Wall Street Journal, I came across a piece on hostile work environments saying it costs companies in productivity and creativity. So this is something new. I worked with Don Imus in WFAN in New York, and someone told me, and Don was nice to me, but somebody told me that they told them never to look at him and to walk against the wall when he was in the hallways. But Don Imus is a different story. So some companies are adopting a no venting rule and the 10-5 rule, which means in the presence of coworkers within 10 feet, you have to acknowledge the person, and within 5 feet, you have to say hello. So in our virtual green room, because we spare no expense, is attorney Maricela Moore. She's a partner at Farrow-Gillespie and Heath. She's an expert in labor and employment law. Hey, Mari, thanks so much for joining us on America Tonight.
Oh, it's my pleasure, Kate. It's always good to talk to you.
So first of all, do you think this is going to be something that more companies are going to want to explore, this no venting thing, because they're having problems with it, and this 10-5 rule?
You know, actually, I don't. And let me tell you why I think that. I think bullying is kind of the hot topic today. You know, what sexual harassment was 15 years ago, where it started becoming a very viable and, quite frankly, really necessary complaint. Bullying has such a broad definition that I think companies right now are saying, yes, we want productivity. Yes, we want to protect our workforce. But to the extent that we have to require that people talk to each other from a particular distance actually goes a bit far, particularly when you look at bullying and the court's resistance to recognize this kind of behavior as something that's protected under federal law. We have quite a ways to go. So, you know, we may hear of some of these policies where the pendulum switches in one particular direction, but for each of those, we can talk about a court who has seen behavior that would knock your socks off egregious that they are not willing to say is protected under any state or federal law that exists today.
Right. So what you're saying is, boy, it would be hard to prove in court if the things that are so egregious, it's not even happening. You're talking about saying that I didn't look up at you and I didn't obey the 10-5 rule. That would be pretty tough. So it would seem as though this would have to be a voluntary thing, just in the trying to throw out memos and get people to be maybe a little bit more friendly or whatever it is they're trying to achieve. But it wouldn't be something that they could hold employees to and put it in the handbook, because it'd be pretty tough to prove.
I think actually if companies started to put something that broad into a handbook, they may create more problems than they're actually curing. But I do think that something that's a little bit more tempered, where there are policies in the handbook about respecting individuals, particularly respecting individuals of different sexual orientations, for example, which is a huge hot topic right now that people don't think about in the bullying context. But quite frankly, since federal law does not look at sexual orientation as what's called a protected class, a lot of those kinds of issues come up in just workplace bullying. So when we advise our clients, we say, look, you need to have in your policy handbook, we do not disrespect individuals regardless of the reason. I mean, there's no reason for a manager, superior, even a coworker to treat other coworkers badly. And I think it's coming about more in a code of conduct where bad managers are being written up for not respecting the culture of the company. And that culture is we respect people's right to come to work every day and not to be, and I'll use the word because it's so frequently used, bullied. But I think that the bullying definition can easily be expanded beyond what is actually protected in the law. So, you know, this is something that is being dealt with every day in the workplace, but it's not necessarily something that's protected in our courts. So it's up to good managers and companies to create their own culture in the workplace to make sure that this stuff never even gets to court. Because if it gets to court, you're talking a whole different standard. But practically speaking, companies, for bottom line efficiency, good morale, workplace reasons, need to make sure they have a culture and a policy in place that says, look, just be nice to everyone else. There is no being rude to people simply because you have more authority. We're not going to go there, and we're not going to allow it. And if you are that kind of a manager, you're not going to succeed in our workplace. And that kind of a policy tends to be more effective than the you must speak to someone if they're so far away from you kind of, ambiguous rule.
Yeah. The other thing that's been interesting, and as this, I think this is going to become more legal turf too, when companies are having problems with this, is social media. Where people are obsessed with their social media and the productivity, of course, is being cut down there. But sometimes with that bullying thing, I've heard that people are using social media that way, and they're taking pictures of people or Instagramming them or tweeting them. Can you imagine if you're the attorney and it's one of the companies perhaps that you represent or you're on retainer or whatnot for your expertise, and they're coming to you with these kinds of problems? I think this is the new frontier, and we're already here because isn't this true, Mari? You can use this in court as evidence. Social media, whether it's Facebook or Twitter or Instagram, judges are saying you can pull it up and you can show the photographs and show the evidence. So that's got to be problematic.
Well, it's so funny because I think sometimes when people get on their social media, they think they're doing it in a vacuum. But as an employment lawyer, when my clients are sued, the first thing that we do is we run a search and we get on Facebook and all of these other websites to do a search on the individual who perhaps may have a claim against my client. And I will tell you, it's been amazing the kinds of things you can find on Facebook where people are not setting their privacy settings, and they will just say things that are unbelievable, not realizing that an employer could get on that exact website and find out stuff about them. So, it's something that people just need to realize. Social media, it's great if you use it in the right way, but really it can be your worst enemy if you're not responsible in the way that you use it. And so companies also are realizing that this could actually be a tool for monitoring their employees, particularly during the workday. I mean, you'll find employees with, no use of internet policies in the workplace, and then you'll have someone that's just right on Facebook in the middle of the day talking about how they're, bored, or they're posting other things which are completely within the workday where they're supposed to be doing something for their employer.
Right. So if I do that and I work for someone and that's one of the policies, that's fireable, isn't it?
Absolutely. If there is a policy in your workplace that says that you are not allowed to use your computer or the internet for personal purposes between the hours of, let's say, 9 and 5 when you're on the clock, if it's not your lunch hour or a break, but at 10:15 in the morning you're on Facebook for a while and your employer finds that because you've left your settings open for your employer, absolutely. You could be written up, and if it comes to worse, you could be fired for that.
Mm. The other thing is, what about if I'm the employee and you decide, okay, you've got some evidence against me, I have these notes in my file and all that kind of stuff, and I scream that it's not fair and retaliation is happening, and that's, retaliation, and I get a lawyer, and I'm going after you for that. Is that something we're seeing more of?
Well, retaliation is actually, I think, the biggest threat to companies in what I'm seeing. And really, the way that it works is under state, Texas particularly, and federal, around the country law, if an employee makes any kind of a complaint of discrimination or harassment, anything that would be a violation of a law, and if they do that in a protected way, they go to a manager, they go to the EEOC, or do anything that is protected, and shortly thereafter, they're starting to be written up, or people say, this person is just the squeaky wheel. She's constantly complaining about something. And then they start writing me up for, let's say, being tardy or being late. It's not the actual discrimination or harassment that I was complaining of that's going to get that company in trouble. What's going to get that company in trouble is that, yes, I might be that complaining employee that, quite frankly, companies don't like employees that are constantly complaining. But once I do something that triggered a right under the law and I complain about it, if a company then starts to write me up, I now have a claim that I'm being retaliated against for making that complaint. And that's something that companies really need to understand, and is that it's not the actual discrimination or harassment I'm complaining about. It's the fact that you've never written me up, and the first time you wrote me up is after I made that complaint. That really gets them in hot water.
Ooh. All right, something to watch out for. There's a lot of people listening in Texas and across the country. And you can check out Maricela Moore, expert in this field, at fghlaw.net. Maricela, we'll have you back on again. Thanks for coming on America Tonight.
Thanks, Kate. Have a good evening.